Hi, everyone. Today we're going to talk about the Stand Your Ground law in Wyoming. This is Christina Williams with Just Criminal Law.
And David Mann, legal storytelling specialist. Okay, so why don't we just start with what exactly that means? The stand your ground law. What does that refer to?
Well, generally speaking, that means you do not have a duty to retreat. When you're involved in an altercation in Wyoming, as long as you're lawfully present at the spot in which the altercation occurs and you aren't engaged in any other illegal activity, you're allowed to stand your ground. You don't have a duty to first try to retreat or leave the altercation.
Okay, so yeah, I mean it seems sort of counterintuitive in a way. You'd think that you wouldn't need to, have that law, but it means that other states are saying that you have to actually go away and not defend yourself before you defend yourself. Is that right?
Right. So, for example, New York, Massachusetts, those are a couple states that come to mind right off the top of my head. Now, if you're in a situation where you are in fear of death or serious bodily injury, you have a duty to retreat if you can. Now, that's not the case in other states, like here in Wyoming. If you're in that situation where you fear for death or serious bodily injury, you do not have to try to leave the situation. You can stand your ground.
Okay, and this doesn't just apply like on your own property. This can be anywhere, right?
Right, you just have to lawfully be present there. That's the only requirement. And so, for example, if you're in a situation where you've been court ordered to not be somewhere, then you're not lawfully present there. And then you can't yourself be engaged in illegal activity, whatever that might look like. So those are the two things that you have to show in order to put on this defense of stand your ground.
Okay, so a scenario might be what? That someone is being sort of chased by someone else and that other person is being, aggressive?
So yes, we can all imagine a situation, say a road rage example, where maybe two individuals are annoyed with each other and it gets out of control. Now, I've definitely had clients who, pull over in a parking lot and a standoff occurs, so to speak, between the two individuals and, they're suffering from this road rage. So that is a scenario where as long as both individuals are lawfully present, if it starts to escalate, and say, for instance, we have a group of kids that are in one car and we have a young adult in another car, and the young adult that's by himself decides to pull off into a parking lot, and the group of kids follow him into that parking lot. And the young adult has a handgun, and he feels intimidated. He gets out of his vehicle. He shows the group of people that he has a handgun, and that causes the other group to back away from him. But we can all imagine, if you've got 5 against 1, how that person in this aggressive situation might feel like they're in fear of bodily injury and perhaps even death.
So if this kind of a matter ever comes in front of a jury, it might have come in front of a jury because something was unclear about this. So does a jury then have to decide, like, oh, it makes sense that that guy would have felt like he was in danger, or is there more of a clear-cut definition of that?
Yeah, so it comes down to, was it reasonable that the person felt that they were in fear of death or serious bodily injury? And in our example, where you've got people that are angry, it's a heated situation, it seems to be escalating. The more time that goes by, the more agitated the parties get. And you've got the dynamic of 5 individuals against 1 individual. And that coupled with the aggressive behavior leading up to pulling over in the parking lot, and then the 5 individuals getting out of the vehicle headed towards the one individual, that person would probably reasonably think that they may end up getting seriously injured in that situation. And so they're allowed to defend themselves. And specifically, they can brandish their handgun, they can point the handgun, and be able to put on a defense of self-defense. Now, they still may be in trouble. They may still get arrested for aggravated assault for pointing the gun, but there is a defense there, a very well-established defense that the attorney would be able to present to the jury.
So in it turns out to be like many other states, someone doing that exact same thing would just be in violation of the law because they didn't try to retreat first. Is that what you're saying?
Right. So say that scenario happens in New York City. That individual, when, they stop their vehicle, get out of the vehicle, and the other 5 individuals start to come at the lone individual, if it's reasonable, they need to try to retreat, get back in their car, drive away, and not stop, stand their ground, and defend themselves. And we can all imagine, that scene of a movie where, the person tries to flee and ends up, maybe being able to flee, maybe not being able to flee. But in Wyoming, you don't have to worry about it. You can stand your ground.
Well, all right. If someone is in that kind of a corner, in that kind of a mess where that happened, how do they get in touch with you?
Sure. We'll include a link in the description where they can call, text, or chat with a member of my team anytime, day or night. Here at Just Criminal Law, we know you only get one shot at justice, so make yours count.